Let me get your attention for a second, please. Welcome to the Judiciary Committee. Let me talk to y'all for just 1 second. I'm going to get Brandy to take the roll in just a minute. We're going to get going. The House is going back into session this afternoon at 3 o'clock. We cannot have a committee meeting that goes past that point in time. So while I had about 10 bills on this for this afternoon, we're simply not going to get that far down the road. We are going to get as far down the road as we go. At that point in time, we will take them up again next week. So if you had a bill on here, if you got a bill that you're interested in and we do not get to it, I am sorry. But we can't go past 3 o'clock and we will not. So with that understanding, when we get to a point where we must quit, then we in fact shall. All right, Brandy, take the roll for me.
Hill.
Here.
Wadsworth. England. Almond. Here. Bedsole. Here. Chestnut. Faulkner. McClammy. Pettis. Here. Robbins. Simpson. Here. Standridge. Here. Starnes. Here. Stringer. Tillman. Here.
We have a quorum. The first bill that we're going to do, Senate Bill 39, Senator Gavan. This deals with the putting on some new judgeships. So please, sir.
Thank you, Mr. Chairman. A long time coming. We've been working on this, and I appreciate you working with me over the last 5 years, and now we finally gotten the bill through the Senate. So I'm really asking y'all not to change anything because I don't want it to go back. But
yes, sir.
I'm waving my hand to be recognized.
Sir. Simpson, go ahead.
Mr. Chairman, thank you for recognizing on this. I would be honored to make the motion for a favorable report on this bill.
All right. There's a motion and a second for a favorable report for Senate Bill 39. And Senator Van, you've done so good. We got about 6 more on here. Could you, is there any discussion on this bill? Seeing none, all in favor of giving Senate Bill 39 a favorable report, say aye.
Aye.
Any opposed? Senator, thank you.
thank you very much.
Appreciate it a lot.
Appreciate it.
Ms. Hall, House Bill 96.
Well, I really wish I had the luck that Senator Gavan had, but anyway, no, thank you, Mr. Chair, members, and I want to say thank you to you and the committee for the time that we've spent with this bill, but I'm also going to ask that this bill be carried over. Each time I come up with an amendment, somebody else comes up with another amendment. And that amendment doesn't fit with the amendment that we had earlier. But I really do appreciate your willingness to work with me. And I want to say also a thank you to members of Faith in Action who have been very vigilant in terms of their support and their work with this particular bill, but also a commitment to you and the members of Faith in Action that we're going to continue to work. But the challenge is always having someone to come to you at the last minute or some changes being made, and it gets frustrating. So you figure the best thing to do is, start over and see where we'll end up. So I want to say thank you.
And we will, Ms. Hall, but let me ask you, while we're talking about it, do you want this carried over to next week, or do you want it just carried over generally?
I'm saying carry over generally, because I think when I come back next week, based on the way things are going, there'll be another amendment.
Okay, Ms. Hall, this bill, then your bill will be carried over. Thank you, ma'am.
Thank you.
Senate Bill 198, Senator Orr. You gonna do that one, ma'am? Please go ahead.
Thank you, Mr. Chairman. This is Senate Bill 198. It's Senator Orr's bill that I'm carrying for him here, and it is a fairly lengthy bill that makes several amendments, lots of cleanup language in here, and it primarily deals with 2 code sections, 13A5 and 5.6, and 1518.8. The crux of the bill, and I think the impetus for the bill was under 1518.8, and really is what deals with Class D felonies. Currently, you cannot, and I can't remember who I was talking to on this committee earlier this week. We had a debate about whether you can be awarded jail time at all for Class D felonies, and I have confirmed, and y'all correct me if I'm wrong, no jail time for Class D felonies. No prison for sure, and no jail time either. So
I think that's correct. But Class D felony doesn't carry any jail time at this point, at this moment.
That's correct.
yes, so one of the problems is that after people have multiple Class D felonies or even multiple within 1 week, not being able to have any judicial discretion to award jail time when it's appropriate has been a problem. And so the primary thing this bill does is to give judicial discretion to order jail time or to order a defendant to community corrections, rehab, supervised probation, things of that nature. It also allows the court with regard to the split sentence statute, to impose up to a 3-year split rather than capping it at 2 years. And it cleans up some of the language of some offenses like attempt of conspiracy and solicitation. And it also no longer requires a split sentence on Class C and D felonies. So with that, I will stop and see if there are any questions.
Questions on this? Yes, sir, Mr. Tillman.
Thank you, Mr. Chair. And these questions not directed toward you, Representative Almond, but the questions that I have is the consideration of our current prison population. So if we look at it, according to the Alabama Sentencing Commission, the past 3 years, about over 1,600 people or 16,000 people were convicted of a Class D felony. Now, based upon this bill, what if 20% of those judges decide to use their discretion and then lock up those 16,000 people? How would that impact our already overcrowded prison system?
I would say would negatively impact that.
I would agree. I would definitely agree with that. Also, with the Class C felonies, the split. So typically on a Class C split, it's 2 years. Now we're increasing it to 7 years. What was the consideration on that?
At this point, Mr. Chairman, I would like to phone a friend, if I may. I have several friends in the audience who are.
Yes, ma'am. Okay. If you could, certainly you can.
Okay.
I've never thought about it quite like that, but that'll work.
That's a good thing. That's a good thing.
Any of you who would like to come up and answer the question?
Identify yourself for us, okay?
Yes, sir. My name is Jeff Bradley. I'm the General Counsel for the Office of Prosecution Services. And with regard to the split sentences on the Cs, what this bill would do, it would reset for Cs back to the pre-2015 Justice Reinvestment Act. So if you have a C felony and the sentence was 15 years or less, you could be split to up to 3 years. And if you had a C that was between 15 years and a day up to 20 years, you could be split between 3 years and 5 years. So it would make the Cs work the same as the A's and B's currently do, and as the Cs did prior to the Justice Reinvestment Act in 2015.
Okay, so, and I'm glad you answered that question. So can you answer the prison population question when regards to the last 3 years, when 16,000 people were convicted for Class D felonies, and typically the felonies were possession of controlled substance. So if you got that's about 80% of those people convicted. So if the judge decided to use their discretion, how would that affect our prison population? Was that a consideration in drafting of this bill?
Well, if I can explain kind of the idea behind it. Yeah. One of the big things that we've noticed in many jurisdictions throughout the state and when I was in Shelby County before I came here, our drug courts, alternative courts, Veterans Court, mental health court, drug court, because of the Class D provision that would not allow a judge to send somebody to prison or jail unless they have 2 priors that are both A or B, or 3 priors that are any classification of felony. You have people that are being arrested for Class D felonies, and they're immediately pleading guilty because they know they're guaranteed probation. And that probation is much less stringent than the requirements of drug court, veterans court, mental health court, where they have to go and see a judge, every week, random drug screens. They have multiple people that are watching them instead of just one PO that is probably, overworked and all that kind of stuff. So they will take felony convictions, knowing that they are guaranteed probation. So they take one, they take two, they take three, and they decide not to come into drug court until they're at their typically fourth prior, have 4 convictions. And then they come into drug court. So I think the question is a little kind of complicated, and I don't know the answer exactly. Would there be more people going to prison? That's possible. That's a possibility, I believe. But I also believe that it would put more people through alternative courts who are first-time offenders that would, instead of being convicted of a Class D felony and taking probation because it's easier, that they would now say, oh, well, I don't want that felony on my record, and I would rather go to drug court. So I think we would be able to steer more people to the alternative courts as opposed to just taking straight probation.
Yeah, and I'm fine with the alternative programs, the mental health court, the drug court, that's fine. So will probation still be a consideration?
Absolutely, yes, sir. Yes, sir. The judge will have the discretion to treat a Class D the same way they would an A, B, or C. They would be able to put them on probation. They would be able to give them split sentences. They would be able to put them in jail if that was appropriate. They would be able to put them in prison if that was appropriate. But it would be at the discretion of the judge. Yes, sir.
Okay. No further questions, Judge.
Mr. England?
At court, well,
Actually,
apologize.
have questions that sort of dovetail right where you just landed.
Yes, sir.
So, I mean, been in the court system a long time, prosecuting, offering diversion, so forth. With the invention of Class D felonies many years ago, one of the number one issues that quickly arose was what you just talked about. And the district attorneys took a significant hit on their programs, diversionary programs that were offered to people because folks were making a decision to plead guilty because it was less of a burden than going through the district attorney's programs, second chance programs, and different things across the state. So I know that part of this is motivated by trying to create punishment to motivate different behavior. But the other part of this is, let's be honest, it's about money too. District attorneys need money. And one of the ways that district attorneys got money was offering diversion programs that were an alternative to conviction. The problem is, as the state's investment in district attorneys went down, the amount of money that people were charged in order to get into these programs went up to the point where they've gotten to be almost prohibitively expensive. One of the things that concerns me about making this available, again, like trying to put these two things on equal footing, so somebody who's making a choice determines, am I going to leverage my future and plead guilty for a lesser punishment, or do I go into the district attorney's diversionary program, which, by the way, most are drafted where they get all the money up front. And every bit of the fines and costs and so forth that are paid to get in diversion goes directly to the district attorney's office, which, by the way, all across the state of Alabama, court systems and district attorneys are often at odds about who pays what and who gets what money. I don't want to see district attorneys now being able to have an incentive, so to speak, to drive people into the diversionary programs, that we start seeing the cost on those go up even more. And one of the things that Judge Hill and many others have worked on for years is trying to come up with a statutory scheme for diversionary programs, so we kind of equalize the cost. So like if you're in Shelby County, for example, the district attorney's program, or even through the city court or whatever, their program may cost you $1,000 entry gate fee, and the same charge, you may go to another jurisdiction and it'd be half that. Because there's no way to normalize the fines and costs that are associated with these programs. And I'm not necessarily blaming the district attorney's offices. What I'm saying is, our lack of investment in law enforcement and our lack of investment in district attorney's offices across the state has created, out of necessity, different ways to fund them. And unfortunately, the one bucket that we keep going into is the one that doesn't pay. So what ends up happening is we drive costs to the people who do pay, i.e., just in Tuscaloosa, for example, it's DUIs. In Tuscaloosa, it's minor possessions, it's possession of marijuana and so forth. So, I mean, I know that's not probably something that you can't do anything about right now, but we got to have some sort of guarantee that if we allow for Class D felonies to now be, it might be possible for them to go to jail now, and people start matriculating towards the diversion programs, that we don't make increased costs on those programs, but they're prohibitively expensive, and people start making the decision to go back to being convicted because the fines and court costs are so much lower than it would be to get into a diversionary program. So I know you can't make any guarantees on that, but it just really concerns me, because one of the things you always see are fines and court costs go up.
Sure. Yes, sir. And to some degree, that is kind of, it's capped in the statewide diversion statute. And it's 1217 to 25 or so, somewhere in there. And it limits the amount of fees that can be charged for defendants that would come into that program.
Unless you pass a local law.
Well, yes, sir. That was my next point. There are.
And that's what happens. That's what we're doing.
Yeah, yes, sir. There are a bunch of local laws, and the only local law that I'm very familiar with is Shelby County, and we're. The way we do it, there's a Shelby County Community Corrections, which is a 501c3 organization, and they are actually the ones that receive all of the funds. The aside from the normal court costs that are assigned to a case, the district attorney's office doesn't receive any funds, nor do the judges. But all of the money goes to that 501c3. And the way we modeled it locally at the time was we looked at the cost of supervision for a typical, at the time it was a 3-year probationary period, which was kind of the standard in Shelby County. And we made the drug court fees match that cost. Now, the cost would be paid. It was designed to be a year-long program. So instead of having 3 years to pay it, you'd have probably 1 to 1.5, depending on how well you did in the program. Right. But it was designed to be cost neutral, where if you went to probation, it would cost you X. If you went to drug court, it would cost X. It was just a different payment plan, was the idea of how we did it locally in Shelby County. And I know that's not how it's done statewide.
No, it's a patchwork across the state of different. Yes, sir. Of different schemes to basically fund the lack of funding that comes from the state.
Sure. Yes, sir.
So, and also, I know we've also pushed some good time legislation as well. Is there any interaction between good time and this legislation here?
This bill doesn't directly address good time, but if someone was sentenced under a Class D felony and they would go, they would. There may be some exception out there, but best I can tell, always a Class D felon would be eligible for incentive good time credit, because the maximum sentence you could ever get. This bill leaves the habitual offender current structure in place, which is you could be sentenced as a C if you have 2 that are both A or B, or sentenced to a C if you have 3 of any classification. So the maximum sentence you could ever get was 10 years. And for incentive good time, you have to have a 15-year or less. So the sentence length would never be a prohibition to being able to get that. I'm not aware off the top of my head of any Class D felony that would otherwise be prohibited, because by definition, none of them are Class A's. I can't think of any other exception that would prevent them from getting incentive good time. So they should get it. Now there may be an exception out there somewhere that's not coming to mind, but by and large, Class D felonies would get incentive good time. Yes, sir.
All right. And last question.
Yes, sir.
If we allow judges' discretion to incarcerate those who are charged with a Class D or convicted of a Class D felony.
Yes, sir.
Functionally, what's the difference between a Class C and a Class D felony?
Right. Under this, a Class D felony would be a year and a day to 5 years. A Class C would be a year and a day to 10 years. A For Class Ds, they would, the Habitual Offender Act stays in place until you have either 2 priors that are A or B or 3. So then you would go to a year and a day to 10. And that would be the cap that you could ever get for a Class D. With the Class C, it would go back to the same structure that it had prior to the Justice Reinvestment Act in 2015. So if you, for a first offense where you had no prior felonies, it'd be a range of a year and a day to 10 years. For a second offense, if you have a 1 prior, it would be 2 to 20. For a third offense, it'd be 10 to 99 years or life. Yes, sir.
Okay. So pre-sentencing prior to the Judicial Reinvestment Act, and I think that is okay. That makes sense. But I do know this too, also, that I think since 2015, there's been an effort to sort of begin to roll back some of the things that we did then. And, you know, comparatively speaking, if we're talking about getting rid of Class Ds altogether versus, you know, I would say a more measured approach here, I would choose this. But ultimately, I wouldn't choose either of them. So anyway, you've answered my questions. I appreciate it.
Yes, sir.
Does anyone else have a question? Yes, sir. Mr. Standridge, go ahead.
Yes, and thank you very much. I want to kind of make sure, understand on Class D felony, like an example of a Class D felony. Is it my understanding that that would be, let's say, what we traditional, like a burglary that is a property value. Is that considered a Class D?
No, sir. No, burglaries, first degree, second degree, and third degree, they are all either in that order, A, B, and C.
Okay.
Felonies, there's no burglary that is a Class D.
So what would an example be that we would see all the time?
Most common example that we would see would be unlawful possession of a controlled substance or theft of property between $500 and $1,500. Those are probably the 2 most common.
Theft or a controlled substance?
Yes, sir. By and large, the Class D offenses, they are mostly property offenses, although there are a few drug offenses, second-time marijuana possession, unlawful possession of controlled substance. Those are also Class Ds. But probably the most common one would be a theft, which would be between $500 and $1,500, or unlawful possession of a controlled substance, or a second conviction of personal use marijuana.
So someone was convicted of, let's say they went on somebody's property and took a utility trailer that was $800. Mm-hmm. That would be considered a Class D. As
far as the theft aspect of that goes, yes. Depending on the facts and circumstances, that may implicate a burglary. Depending on where it was. If it was, for instance, if it was in an attached garage that they broke in to do that, then it might.
Just on their property, but not in the building.
Just on that property aspect, yes, sir. Because
so
the property would be $800.
And under existing, it wouldn't merit any kind of jail time for that.
Currently, they would not, unless they had 3 prior felonies of any classification or 2 that are both A or B. Otherwise, they would be guaranteed probation. Yes, sir.
And this bill would give the judge some discretion in those type cases?
Yes, sir.
Okay. Thank you.
Yes, sir.
Quick question. I don't know if it's a quick question, but what's the estimate of how many persons that may be subject to losing their rights of these these programs, community programs that can go into and be sent to an institution instead?
I'm not sure I follow the question. I'm sorry.
Okay, what I'm asking is, if you remove this section that says probation will be revoked, how many do we have right now that you foresee that could possibly be going into an institutionalized instead of not having an opportunity to go into one of the outpatient? I'm saying outpatient, the community service-based programs.
Are you talking about the amendment that adds in, I think it's in 2254 or something like that that's in the bill? Yes, ma'am. I don't know. I don't know because like my experience in Shelby County, we would only order someone to a like a rehabilitation center or something like that, if there was some evidence that was an issue. For instance, if they were picked up for a theft of property, like we talked about, that would be a Class D, and they have 2 prior felonies that are unlawful possession of controlled substance, and they have a couple of unlawful possession of marijuana. So they have kind of a history of, kind of drug use, drug charges, that kind of thing. So we would, based on, there being some kind of evidence that would be something that would be needed that could help them, then we would order those people as part of their probation to go to a treatment facility. Currently, because if they are ordered to a treatment facility now, because of the way the Class Ds, the probation violations for all of them, really, that is not an offense that the courts can do anything other than a dip or a dunk under. If they're ordered to go to a treatment facility and they just walk off, they say, Judge, I'm just not going to do that. Thanks for, thanks for ordering me to, but I'm just not doing it. The most the judge can do is either a dip or a dunk, and then put them right back on probation, order them again. Still, the judge has no ability to really enforce that. So that was the idea behind putting that in that code section. So now if somebody gets a new offense, if they abscond or if they're ordered by the court to go to one of these treatment facilities and they absolutely refuse, then the court would have the ability to revoke them and impose a split, impose the full sentence, whatever the court felt would be best. Does that answer your question? I'm not sure that it did.
What up? What up?
Okay.
Mr. Wadsworth.
I just want to ask, if a defendant is sentenced and he goes into a program and just walks off the program, you said that there's nothing a judge could do, but is he not going to be charged with absconding?
Well, if he'd have to meet the definition of absconding, which is specified in the code. Just failing to report and absconding, they are 2 different things. So if I just am not reporting, not paying my fees, that kind of thing, that wouldn't necessarily meet the definition of absconding unless I'm taking some kind of steps to actively avoid it. Like I'm not reporting, but I've also run.
If they don't report to the probation officer, is that going to be, what will that be?
Just failure to report is a technical offense, and the judge would not be able to put them in jail for more than 45 days on a technical violation.
What is the difference between absconding and escape?
Absconding and escape are very different. You have to, for escape, you'd have to be in custody. So you would be, say, like maybe at a jail, or you've been sentenced to a jail, or they're taking you into custody when you're arrested.
Or if you're in a program and the judge orders you to return if you leave that program, that's going to be an escape too, correct?
Not necessarily, no, sir. Because they wouldn't necessarily meet the definition of custody for the escape charge.
Okay, thank you.
It would depend on all the facts and circumstances, but as a general rule, it'd be difficult in that circumstance to charge them with escape, in my opinion. Yes, sir.
I got a question for you, Jeff.
Yes, sir.
I'm familiar. I got off the bench before we came up with Class 2s.
Yes, sir.
However, I'm familiar with sentencing under the guidelines.
Yes, sir.
Under B's and C's. Would there be, and this might be a better question for Biddy, would there be a schedule similar to the schedule that we have, the worksheets and everything that we see on the B and C type offenses? Would that also come into to deal with the D's? They're already in place?
Yes, sir.
They're in place, but yet well, okay, man. In a C or B, there's a mechanism by which that individual can be incarcerated. And in D, what we've done is just remove that mechanism that you're saying. So by passing this, what we would do is put that mechanism back into the mix. Is that pretty much the idea?
Yes, sir, Your Honor.
Okay, so if an individual scored out a score such that probation was recommended and that was not going to be imposed, would an order have to be entered delineating why those guidelines were not being followed, which is what has to be happening. Which is what has to happen if we're not going to follow the guidelines and the other sentences.
Yeah, yes, sir. And Bennett can correct me if I'm wrong, but as far as I recall, there are no Class D felonies included in the guidelines that are not presumptive. They are all presumptive. So in order for the court to be able to go outside of the recommendations of the guidelines, there'd have to be an aggravating factor that was either proven or agreed to by the defendant. So yes, there would be required an order that would find the aggravating factor, and then they could go outside of the guidelines based on that aggravating factor.
Okay, so the truth is, on an initial appearance on a Class D, and someone works the guideline, and it's a first Class D.
Yes, sir.
That individual is never going to be presumptively sentenced to incarceration.
Yes, sir. That is absolutely correct, because under the guidelines, it would be a probation recommendation, which were presumptive. So even if an aggravating factor was proven and it was sentenced under the statutory scheme prevents them from being able to be sentenced to jail or prison also. So in that circumstance, assuming no prior felonies, and we're not in that, in that circumstance, they wouldn't be able to be sentenced to jail or probation or prison under the guidelines, nor if an aggravating factor was proven under the statutory sentencing scheme either.
So it would really follow the same basic thought process I always had on a C. First offense, they're going to get a probation recommendation and going to get probation.
Yes, sir.
Okay.
Yes, sir.
That makes perfectly good sense to me. I couldn't believe it'd be otherwise, but I figured you'd know.
Yes, sir.
All right. Any further questions? Is there a motion to give this bill a favorable report?
So moved.
So moved. There's a second? Second. Thank you. All right. We have got a motion and a second. I think Mr. Betzel made the second. Okay, there's a motion and a second for favorable report. Any further questions? All in favor say aye. Aye. Any opposed?
Opposed.
All right, we have a favorable report. Ms. Allman, thank you very, very much. We
Thank
appreciate
you,
it.
Mr. Chairman and members.
(206) Representative Chambliss. Oh, you gonna do it, Matt? Great.
Mr. Chairman, before I speak, I've noticed a pattern, if you don't mind. The district attorney for Baldwin County is here. And I know last week they had the district attorney from Tuscaloosa County. I think they're trying to keep Representative England and I in check by having our district attorneys here. And as a former employer, where I used to be an employee of District Attorney Wilters, I do want to let you guys know that the DA of Baldwin County is present in the room today.
And listen, we appreciate it, Mr. Simpson. I guess they're never going to bring the one from St. Clair County because they just didn't figure he'd have much of a chance. Is that the deal?
Members of the committee, I bring to you now Senate Bill 206, which is the organized retail theft bill. We have had a public hearing on this. This was Representative Treadway's bill. He can't be here today. That's the only reason why I'm carrying it now. After our public hearing, there were some amendments that were drafted and made. Those amendments will be, I'm hoping to offer those amendments to this bill from the Senate that address our concerns about the threshold being met for organized retail theft. And with that, I'll take any questions.
Well, why don't we do this? Let's go ahead and talk about the amendment, because I think what the amendment does is set out some of the range of amounts of theft. Doesn't it, Mr. Simpson, is that right?
Yes, Mr. Chairman. With regard to, and I'll just go line by line, on line 168, page 6, theft of one or more items of retail merchandise, the aggregate value of which exceeds $2,500 in retail value during a 1 year or longer period constitutes retail theft. So they've got it as 2,500. Then they have the next level is 1,000, exceeds 1,000. Then the next level will exceed $500 in a 30-day period. The periods drop as well as the threshold of the amount. So the aggregate can only be, if you're more than 2,500, that's a year or longer as far as the aggregate during during a 1 year period. For a 180-day period, if you're using $1,000 or more. So as the value of the amount drops, the period drops. So you don't want to get somebody that stole $500 one time and then a year later they do that. That's not what they're trying to do. If the aggregate value is lower, they decrease the time that's used. So they took some of our concerns into drafting this opinion, in this amendment, and I think that's kind of answered some of the problems that I had with it.
Mr. England, please. Tell you what, before you do it, Mr. England, let me do this. I'll offer this amendment, Mr. Simpson.
Thank you.
Second.
Okay, so there is a amendment that has been offered and seconded, and it is it's what you just went over, and it's exactly the same amounts that are shown previously in this bill for the theft. This is really more of what I used to call receiving stolen property, isn't it, ma'am?
To an extent, yes, in an organized retail theft manner. So, like, if you're having a smash and grab situation or something along those lines, they aggregate the retail value from that perspective.
But it's the same aggregate amounts as were reflected earlier in the bill for the theft.
Yes, sir.
Okay, then I'll offer this as a second. Does everybody understand this? Is there any discussion on this? If not, all in favor of the amendment, please say aye.
Aye.
Any opposed? Okay, your bill's amended now, Mr. England, please.
My DA's not here, so I can act a fool. Oh, no, just.
People have been waiting for a Simpson England fight. We just hadn't had one this year.
And that's going to be on pay-per-view. But no, I want to, first, the bill, and I think it was almost unanimous agreement that there was an idea, but this one kind of went too far initially. And through the process, we've seen it kind of narrowly focused on the kind of conduct that we want to criminalize. And throughout that process, I was initially like a hell no, right? But through working with you and many others, and also through the Senate, and also, I got to say, Tricia burned me up on this. So she's kind of melted away some of that opposition. So the bill sort of makes sense to me now, especially with the amendments that were added in the Senate about the point of sale, shopping cart business, which I learned here recently, shopping carts can be pretty expensive. But also through the putting some of the thresholds in it. So now we're actually driving towards the conduct to punish the people that we're looking for, instead of the folks that we talked about, minor shoplifters looking at a Class B felony. So I'm actually going from, no to, I might even consider voting for it. It has nothing to do with you, though.
I understand.
Okay. And, and that big blow up is coming. I don't know when yet, but it's coming.
We're running out of days, man.
All right, we got to do something. Anyway, thank you.
Okay, Mr. England, any other questions on this bill? That's the only amendment to it, isn't it, Mr.
That is the only amendment.
All right, ladies and gentlemen, you have Senate Bill 206 as amended. Do I hear a favorable report? Move a motion for a favorable report in a second. Okay. There's a motion and a second for a favorable report on Senate Bill 206. Is there any further discussion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, Mr. Simpson, thanks. Is Representative Ingram here? Okay, I'm sorry. I didn't see you come. I knew you told me you thought you might be a second late, and I was sort of trying to watch for you, but I didn't see you. But Representative England, let's talk about House Bill 301.
All right. Yes, sir. I'm lucky. I know nothing about this. I'm a lost ball in tall grass, but I was a lucky one to carry it, and probably one of the luckier ones to get sent to 2 different committees. So I've won the prize, I can tell you that. But the concept of the bill is a great bill. I'm carrying it for a DA Association. It passed in the last committee with no issues. And this is basically just keeping the firearms out of the hands of convicted violent offenders, felons. And anybody that's on bail for murder or rape or something like that, it keeps the firearms out of their hands. And I've got the DA Association here. If you have any questions, if I can't answer it, more than likely I can't, but I'll be glad if I could recognize them, Mr. Chairman.
Certainly you can. I think we have at least, I know we got one amendment. Do we have 2?
I've heard of two. One I don't like, but we may have to suck that one up.
We'll have to, well, you're gonna have to listen to both of them, or
Right.
or we'll worry about it next week, whichever one you want to do.
No, let's move forward, sir. This has been about 5 weeks in the making and 2 committees, so I'm ready to.
No, and I don't
move
blame
on.
you for that.
Yes, sir.
Okay. All right, I've got an amendment. Does anybody, don't you have one? Go ahead, Mr. Hudson.
Yes, sir. My amendment, we'll take a look at page 5 after line 124, but I'll say this, to really understand the context, you'll have to start way back on page 2,
Okay.
where it says, as used in this act, the term felony dangerous to human life shall include any of the following. There's a list of 28. This would simply add 29, and this is just simply to capture anyone that is a attempt, and it reads, any attempt on any offense described in this section which constitutes a Class A or Class B felony.
I consider that a friendly amendment, Mr. Chairman.
Okay, that's the amendment. Is there a second? Go ahead, Mr. Simpson. Okay, this amendment is seconded. Is there any discussion on this particular amendment? Okay, then all in favor of adopting this amendment, please say aye.
Aye.
Yeah, that's amendment number 1. All right, Mr. Ingram, let me talk to you about amendment number 2, which I consider to be a friendly amendment.
Did you want to do this one on the floor, Mr. Chairman?
No, sir.
Okay, go
Do
ahead.
it right here.
Yes, sir. I had to ask. Yes, sir.
I do not. I want us to look on,
We didn't adopt the
do what? That's right. I'm sorry. Let me back up. Good point. Is there a motion to adopt the substitute bill as presented?
Well, do we need to withdraw the amendment that we just put on so we can adopt the sub and then put that amendment on the substitute?
Yes. Okay. So
I'll make a motion to
withdraw that amendment. Are you okay with that, Mr. Bedsole? Yes. All right. Is all in favor of that, say aye.
Aye.
Is there a motion to adopt the sub? Thank you. Is there a second? Second. All right. All in favor of adopting the sub, say aye.
Aye.
All right. The sub is adopted.
I make a motion to adopt Representative Bedsole's amendment.
And Mr. Bedsole, you again, you second that also,
Yes.
correct? Thank you. Thank you all very much. All in favor of that, say aye.
Aye.
All right. Now we're back to your bill as amended once. Okay, Mr. Ingram? All right. I have an amendment. I want you to look on page 6. Page 6 is going to be lines 144 through 156.
I don't have a copy of the bill. Just tell me the guts of the amendment.
Sure, I'll be glad to. The bill as it's present, and let me say this to Trish, because just I agree with what Chris said. She has worked remarkably well to bring this into a point where it's much, much better than it was, I think, when it was originally dropped. And I do appreciate the effort that she has shown and what she has done. However, let me tell you what my issue is at this. I'm good with this bill except for these amendments. This amendment, whether it be on page 6 or 7, lines 144 through 156 or 169 through 180, those 2 areas of the bill do not allow for judicial discretion in sentencing. They require day for day. They remove the ability of a judge to give probation. They remove the ability of a judge for community correction. They remove the ability of the judge for split sentences. They remove the ability for any type of early release, work release, good time, or any other program that would change the time or location of incarceration. Here's my problem, Mr. Ingram, in a nutshell. I sentenced for 19 years. I had a lot of different tools at my discretion as I went about sentencing people, and I used them all.
And you were a good judge, I heard too, sir.
Well, I like to think so. You could probably get some different opinions on that, perhaps from the audience, but be that as it may. I think discretion on the part of a judge is why we elect judges. I think to remove discretion from a judge is a mistake. And it is my opinion that we should give judges the complete discretion that they have within the framework of what the law is, so that they can sentence in a manner that they deem to be appropriate based on the situation in which they find themselves. You know, we look at the various branches of government. We're in the legislative branch, and we must pass laws, and I understand that. The executive branch must execute those laws, but the judicial branch of government is for discernment, and the judicial branch of government is to interpret those laws. And I think to remove the ability of the judicial branch of government to discern and to have that discretion, we've talked about it here today. Class D felonies, there needs to be discretion to hold those folks accountable. Discretion on the part of the judge, in my judgment, is always something we should do. Now, if the situation is, does every judge use good discretion? The answer to that is, of course not. Does every district attorney use good discretion? Of course not. Does every minister use good discretion? Of course not. Nevertheless, I do not want to remove the discretion from any of those, most especially not from the judge.
Yes, sir.
Consequently, I'm going to ask and I'm going to offer amendment number 2, which removes the part of this bill that disallows judicial discretion.
Can I see a copy of the amendment?
Sure.
Speaker.
Okay.
Does it say?
It doesn't. All right, it's hard for me to listen, Reed. I do well to read 2 feet from my foot.
All right, so it removes line, you want to, oh, maybe I don't. Okay.
You may need a copy of the bill to look at.
I've got a copy of the bill. I've gotten it.
Okay, I'm
looking. I've got the bill.
Yeah, it's a sub to what you need to look at. Discussion. All in favor say aye.
Aye.
Aye. Any opposed? Got a favorable report as amended. Thank you, sir.
Thank you, Chairman. Thank you, members.
Mr. Tillman, are you ready to go forward with yours or not? I know I told you we probably wouldn't get there, and I really didn't expect us to, but we have, and I'm grateful that we've gone as far as we have, done as good well as we've done. I can do it if we get time. Oh, wait a minute. Is there a public hearing on this bill? On this part?
It is, but I don't know who called the public hearing.
Okay. Has anybody signed up for it? We can do that. Hang on, Mr. Tillman. Give us a second.
Yes, sir.
Just kidding.
Is there anybody?
Let me ask you this, ladies and gentlemen. Let's talk for a second. We got a minute. Is there anyone here who came here today for the purpose speaking on House Bill 436, which is the bill that deals with youthful offenders. If nobody's here, then there is no public hearing. Go ahead, Mr. Tillman.
All right, thank you, Mr. Chair and committee members. HB 436 deals with our Youthful Offender Act, or commonly called YO. This bill does not address any of the substantive portion of the bill. It only deals with the age requirement of 21. And the reason why is through my practice and different counties, different jurisdictions, some judges, when they use their discretion, they will deny a person who is 21 the YO hearing, the YO investigation, an opportunity to be heard on the facts of the case. This bill right here would just make it more consistent and make it more definite that if you are 21, you can still go through the process of a probation officer investigation, opportunity to have a recommendation from the PO report, to have a hearing with the district attorney presenting evidence, facts, criminal defense attorney doing the same, and the judge making the decision to see whether or not they would grant that particular person the YO status.
Okay, are there any questions for Mr. Tillman? The purpose of this bill really is just to set lower than 22. Less than 22 is a youthful offender.
Yes, sir.
Any questions for Mr. Tillman?
Just
Go ahead, Ms. Holman.
to be clear, Mr. Chairman, it's still at the discretion of the judge
Yes.
whether to award it. Yeah.
Doesn't change any of that. It's still up to the judge to make the final decision on whether or not to grant them youthful offender.
Okay, is there a motion to give this bill a favorable report?
I move to give this bill a favorable
All right,
report.
there is a motion and a second.
Second.
Thank you. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Okay, the ayes have it. You got a favorable report, sir.
All right, thank you, committee.
Folks, we got a few more public hearings. Anybody here on 441, which is Mr. Robbins' bill?
Yeah, AT&T.
Hey, Brandy, Pettis was a no. Pettis was a no. Pettis was a no.
Good. That's fine. You know, in all honesty, we didn't think we were going to get to these public hearings, which is fine. We're certainly willing to have them, okay? That's not a problem. Mr. Robbins, why don't we start with you explaining 441, and then we will certainly let you speak, okay?
Okay.
All right.
I have House Bill 441, and I have a substitute for it. Do we want to,
Let's tell us about the sub, and we'll talk about adopting it.
Okay, the sub changes some language that Representative Simpson had a concern about privacy. We took out a provision concerning government issue IDs because of that, and we took away a cause of action that Representative Faulkner had an issue with, and we added a severability clause. So if any portion of the bill is deemed unconstitutional, it would be severable. So that way the bill, once it became an act, would still be able to travel, and it wouldn't eliminate the entirety of the act. So that is the substitute, and what the difference between the sub from the original bill. Do you want me to go into the substance of it, or just?
In a second, I do. Is there a motion to adopt the sub?
I'll make the motion to adopt the sub.
Thank you. Is there a second? Thank you. There's a motion and a second to adopt the sub. Are there any questions on this? On the adoption? All right, all in favor say aye. Aye. Any opposed? All right, the substitute is adopted. Mr. Robbins, go ahead, explain it.
This bill is targeting the pornography industry, specifically trying to prevent pornography from children having access to pornography, and is across basically the internet. And we, in the bill, define what obscene material is to children based on previous sections that we have are harmful to children. And we will have a division, the Consumer Protection Division of the Office of the Attorney General's office will be the entity that runs this, and a company that wants to distribute material in the state of Alabama online would have to register with the Office of the Attorney General. A fee would then be set by the Attorney General. Half of those fees would go to the Attorney General's office to oversee this, and half would go to the Mental Health Trust Fund. As we see, all statistics show that pornography, the more pornography you see at a younger age, the more hypersexual you are, the more violent you become to the opposite sex and the way in which you view sex with your companion. So therefore, we have to counterbalance some of the harm that's being done, and having those fees paid into the Mental Health Trust Fund helps offset and provides us those avenues to help our young people. The other thing that this bill does is after the registration, a commercial entity is required to have a age verification process on their website. And age verification is, you have to, in essence, that's what it is. You verify how old you are. You have to verify that you are at least 18 years of age to then access that website. And we say it has to be done by commercially reasonable means. And commercially reasonable means are anything from in some states, they're using biometrics or facial recognition, or it could be as like when you do a credit report, you have to give certain data to show that you are an adult and you are the person you're claiming to be. And there's apps out there that allow you to create an anonymous identity that you can then use online that would then show you're an adult. So you could then access those websites through the anonymous app that you have. And so if a company fails to register, fails to have the age verification process, it would create a cause of action for a parent. It would also allow the Attorney General to pursue an action against that commercial entity that failed to do those two things. And also what it would do is any violation of this act would be a violation of the Deceptive Trade Practices Act, would allow you to sue that company, and the Deceptive Trade Practices Act comes with punitive damages. So if a company fails to perform the responsibilities that they should do as a pornography distributor, you would have punitive damages against that company. And also to protect your privacy as an adult, if they save any data from you, you would have a cause of action against that company, and that goes beyond just the typical fraud, but you would have a cause directly against that company for keeping and storing your data. So that's the bill. And I guess this is the public hearing. I don't know if there's any questions, or you want to move on to the public hearing part.
You want a question, Mr. Chestnut?
Yes, I have a few questions. One question is this pattern after a similar statute, or is it completely novel?
It started as a completely novel process, and I have taken some language from other states. No state or country, as far as I'm aware, from where let's say has a registration component, which in my mind is the part that creates the hook that the Attorney General's office can use that will make it stay constitutional. There could be other constitutional challenges, but there's nothing unconstitutional about making a business register within your state to operate. So, it was a little here, a little there, but some new ideas too.
Okay. So just a little commentary. So the only reason somebody would be against this is what would be the reason someone would be against this? That's a rhetorical question.
Yeah. I guess I'd say any privacy concerns, but you'd make the choice yourself to go to the website.
All right, we have a public hearing. We're not going to vote on this today, Mr. Robbins. We will vote on it next week. And from today on, though, folks, any public hearings we have will have to be voted on the day of the hearing. I like to give you all a week, but I don't think we got it. I don't think we got the time. Sir, you wanted to speak? Identify yourself if you would.
Cleo Washington, Vice President for AT&T, Chairman Hill, Vice Chairman Wadsworth, Ranking Minority Member England, and members of the committee. I had an opportunity to talk to Representative Robbins about a week ago about the bill, and obviously it was still in the process of being worked through the changes that would be made. At the time the bill was filed, we requested a public hearing in part, and I want to put this in a proper context, because the discussions were on House Bill 298, which was Representative Sales' bill, which you all voted on yesterday, and whether there would be a substitute for the bill. And what the industry, the wireless industry, proposed through the National Wireless Association, CTIA, they appeared at the public hearing, and they talked about the fact that all the wireless providers already provide for filters. Everyone, of course, has the same desire to protect children and what was the best methodology. One of the things I talked to Representative Robbins about, and now with this sub, I think it's still in there, but I'm not totally certain. I haven't seen the sub, was what they did in Louisiana, which was the process that we, the wireless industry, has vetted across the nation, and that is a process of registration. Of age verification. And I think if I heard correctly, Representative Robbins is adding registration, which sounds like a very good idea. But again, the purpose of the hearing was because we had not had an opportunity to review anything, and it was all of this discussion about what would be included. We thought yesterday that at least the age verification will be part of the process that was amended into House Bill 298, and it was not. But Mr. Chairman, that's the reason we asked for a hearing, to have an opportunity to have this discussion and to figure out what exactly was in the bill.
Mr. Simpson, you got a question?
Now that we've gotten to where we are in this point, and I can tell you from personal experience with Representative Robbins, he's always willing to listen and talk to you guys and work any issues that you may have. So between now and next week, do you think you can get with Representative Robbins before we vote on this bill, and any language that you guys need added or removed, and any questions? I know Representative Robbins is very, very amenable to like working with people.
Yes, sir. And I appreciate it. Actually, we spoke for about an hour on it. Now, because the 298 dealt with imposing some additional responsibilities potentially on retailers as well as manufacturers. And so, but yes, I'll be more than glad to. And I assume the rest of the industry will too. Were there any other questions?
For Mr. Washington.
So are y'all against the bill now?
Again, Representative England, I heard it sounded good. I would still like the opportunity to read the sub.
Okay.
So it sounded very good. And like Representative Chestnut said, who's really going to be in opposition? I like the.
All right. I just know the days are getting short in this conversation.
Yes,
this
sir.
is still a House bill, right?
Yes, sir. It is.
So if this is like a conversation that can carry on as the bill goes through the process, and maybe if we're getting to a point where there's more agreement, I just don't see why we would keep it here today knowing that we're running out of time in the session.
Well, again, I can only speak on behalf of, like I said, there are many folks in the industry that were involved in the discussions, and so I can't speak on behalf of them.
All right.
Ms. Lindsay, is there Ms. Lindsay? Is there anyone else here to speak on this bill? Come on up.
Thank you.
Mr. Washington, thank you.
My name is Knox Argo, and I represent the Motion Picture Association, and we heartily endorse this bill. We would bitterly oppose the one that Mr. Sales has worked on so long and so hard, God bless his soul, as being totally unconstitutional. This bill has a chance of being an actual law enforced. It also puts the burden on the porno sites and not the business community, which we hardly endorse. So I'd love to see y'all vote this thing out today so it could get over in the Senate, because I know the bill that was passed is sitting in the Senate Judiciary, and I think they're waiting on this bill to come along so they have that option. Yeah, we're for it.
Thank you, Mr. Knox. Mr. Hargrove, I appreciate it. Anybody else? Yes, sir, Mr. Chestnut. Oh, I'm sorry.
Quick
I'm
question.
sorry, Mr. McLean.
I heard him, no, that's fine. I heard him mention that it's been in the Senate. Has it gone through Senate committee? It's a companion bill, or we're not sure?
And I don't know the answer.
What was your question, Penny?
I said I heard that it's in the Senate. Is this like a Senate companion bill? Has it gone to the committee up in Senate?
No, there's not a Senate companion. They were talking about the bill we passed. Mr. Argo was talking about the bill we passed yesterday is up in a Senate committee.
Sure, I can.
Mr. Chair.
Is there a motion that we take this bill up today? So moved.
So moved.
I just have a quick question. Representative Robbins, this substitute that we adopted today, this is the substitute that you had on the floor yesterday that Representative Sells asked that you tried to present Representative Sells' bill. Representative Sells said, make that your own bill, right? Same version?
Yes.
Okay.
And he did. Mr. Tillman.
Well, that was my question, to make a motion to take it up today.
Okay.
Well, before y'all do that, I guess I would like to say that if Mr. Washington has any issues, I would be amenable to working with him. And if we need to make an amendment on the floor, I'd be up to a floor amendment. So if we want to vote today, and I'll continue those conversations.
Mr. Washington, is that satisfactory with you? Mr. Washington, thank you so very much. We appreciate it. You know what, Chris, I've been told no a few times before. I'm pretty immune to it. Okay, there's a motion to go ahead and take this bill up today. All in favor of that, say aye.
Aye.
Any opposed? Now I will accept a motion for a favorable report.
I so move.
Is there a second? Second. We got a motion, second. All in favor, say aye.
Aye.
Any opposed? Okay, favorable report. Thanks.
Thank you so much.
Let me do this.
You gonna handle yours? I'm shocked that you made it this far.
Okay, Mr. Wadsworth, you ready?
I am. Judge, Chairman, would you explain your bill, please?
House Bill 38. We have presumptive sentencing guidelines in this state. And as those are worked, it is mandatory that a judge follow those sentences. Let me tell you what this bill does. It says, and it's found really on the last page in line 87, 88, and 89. It says a judge may deviate from the presumptive sentencing standards if a defendant is convicted of an offense after requesting a jury trial. So here's the deal of this bill in a nutshell. If you've got presumptive sentencing guidelines, that is an offer. And that offer can be taken by a criminal defendant or rejected. If that offer is rejected, then the guidelines at that point are out of play. And the judge, again, I'm pretty consistent. Goes back to the discretion of the judge to sentence the individual at the conclusion of the trial in the event that that person's found guilty. I'll be glad to answer any questions.
Is there any question?
Mr. Chairman, I think this is an exceptional bill and would make a motion for a favorable report.
Second. Is there any other questions? Being no other questions, all in favor, give the bill a favorable report, say aye.
Aye.
All opposed, bill gets favorable report.
Thank you. Ladies and gentlemen, that concludes our meeting. And to get to the committee, thank you all very much. I had absolutely no earthly idea we were going to get this far today. So thank you for your work. Shows that you've read this stuff before you get here. Thanks a lot. Work. Shows that you've read this stuff before you get here. Thanks a lot. Good.